new charge of petty larceny and using or possessing drug paraphernalia. That's 24 CR 09476. Then, depending on the outcome of that case, I have a potential revocation hearing for a simple battery charge.
This wasn't, stealing a sandwich or something like that from a convenience store, something food or drink like that that's necessary for survival. Is a larger amount of $329. City's recommendation will be for a 30-day jail sentence up front, consecutive to anything else.
It's not much help to point out that you're not a felon, that you're just a repeat misdemeanant. That's not really given the court a lot of comfort.
This courtroom is already buzzing with tension. Petty larceny, drug paraphernalia, and even a looming battery revocation. The defendant faces multiple charges, and the judge wastes no time laying out the stakes. Buckle up, this case has layers. Subscribe now for more shocking courtroom breakdowns that pull you right inside.
New charge of petty larceny and using or possessing drug paraphernalia. That's 24 CR 09476. Then, depending on the outcome of that case, I have a potential revocation hearing for a simple battery charge in 24 CR 04854. Mr. McGinnis, have you had a chance to talk to your client this morning?
I have, Your Honor. It's my understanding he wants to enter a no contest plea. Hopefully the petty larceny and the city would dismiss the drug paraphernalia.
Mr. Alton?
City would be willing to do that. I would just note that I would ask that he agree to pay the $315. Unless, let me check to see if that was, I apologize, to see if that was recovered.
Please do.
I added up the value of the items that were stolen. Oh, I apologize, it says $329.02 is the total amount actually. And they were recovered, Your Honor.
They were recovered, okay. And there's no indication that there's any other injury that would require a victim impact hearing or restitution hearing or anything of that nature. Is that correct?
Correct, Your Honor.
All right, I feel comfortable proceeding then. All right, Mr. Connor, the action is to you, looking for a plea on the petty larceny charge. Have you had a chance to talk to your attorney about that this morning?
Yes, I have.
How do you wish to plead, sir?
No contest.
All right, and you understand when you plead no contest, although you don't necessarily admit the truth of all the allegations against you, you do concede that the city has a factual basis that would support the charge if the matter went to trial. Is that correct?
Yes.
All right, so I'm going to enter judgment against you on the petty larceny charge. I find that the plea is knowingly, voluntarily, and intelligently made with the assistance of counsel. In exchange, the city is moving to dismiss the paraphernalia charge, and that charge is dismissed.
The judge dismisses the paraphernalia charge, but the victory is hollow. The city pushes for jail time, pointing to stolen goods worth over $300. This isn't survival theft, it's a repeat offense. What do you think? Strict jail time or suspended sentence with supervision? Drop your thoughts in the comments below.
I'm going to take this one step at a time. I want to dispose of this matter first, then we'll talk about the other case. Let me hear from the city first on sentencing for the petty larceny charge.
Your Honor, he was already under a suspended sentence on a battery. That was to be consecutive to any other charges according to the court's docket. This wasn't, stealing a sandwich or something like that from a convenience store, something food or drink like that that's necessary for survival. Is a larger amount of $329. City's recommendation will be for a 30-day jail sentence up front, consecutive to anything else.
Mr. McGinnis.
I appreciate, Your Honor. I can certainly understand the city's position. I could assume, based on that presentation, that they're probably going to be requesting revocation on the other case as well, where it looks like he has 30 days, which would amount to a 60-day sentence, and then he would be done with his cases, and he wouldn't be on supervision. I think he probably should be on supervision. I think this court should take in consideration that he did commit a new offense while he had a suspended sentence. I don't think just sentencing him to jail is going to stop him from committing new offenses. I'd ask the court to sentence him to 90 days on this case suspended for 1 year on the conditions that obey
I
all
like
laws.
to do more time than the
Mr. Connor, hold on.
Yeah,
I will hear from you. Do not worry. I will hear from you directly.
Well, Mr. Connor, do you just want to do 60 days in jail, partner? I apologize, Your Honor. He's been a bit difficult this morning to have a conversation with.
That's okay. Mr. McGinnis, let's
I-
just you and I talk real quick. Let me hear counsel's recommendation, then I'll talk to Mr. Connor. I have an idea in my mind kind of where I want to end up on this.
Thank you, Your Honor. And I try to talk to him about community court. He's not interested. He doesn't have a social security card. It sounds like he does have an apartment. He's been looking for employment. I think there's a lot of resources out there that he could take advantage of that he hasn't taken advantage of. I'll submit it.
Okay. All right,
Your
Mr.
Honor,
Connor.
if I may just add, the police report does indicate as well that this is his would be his 5th petty larceny conviction in the last approximate year and a half. So
All right.
we have that as well. The risk assessment also indicates a history of nuisance and fail to handle court matters. So the city's estimation is that it's just not a good candidate for probation.
Okay. Mr. Connor, I've heard from both of the attorneys on this. I understand you don't necessarily agree with your counsel's tactic. I will let you know that where he's going with this is in an attempt to keep you from doing actual jail time today. The suggestion is a longer on paper sentence, but the idea is you don't actually serve it. So he's not saying that you should do more time. He's saying that you should have a larger sentence hanging out over your head so the court feels comfortable giving you a suspended sentence in this case, just so you understand where he was coming from. I understand you maybe want a different outcome here. The law affords you an opportunity to address the court before I impose the sentence. So whatever you'd like to say, now's your chance, sir.
Your Honor, I just want to humbly ask for some sort of lenience in the matter because the 30 days, I know I had that. The petty larceny, I was just out of my element from the heat. Plus, all I'm trying to work on, because I've established a place to live. I've been establishing my identification, doing this without program. What I'm trying to do is ask you if I can just consolidate everything with the 30 days and then have, pardon me, a suspended outside of that one to give me a little bit of room because at this summertime I have been doing positive, yet and still I have had the petty larcenies, but I don't commit any felonies. I haven't been felonious in the community. It's always been something small, and I really am outside of those behaviors. I do have things to care about and things to warrant my cooperation as far as staying out the way. How about it? Maybe a 90-day suspended, and I do my 30 revocation, and I go from there. If that okay with you?
Well, sure. I'm going to think about this for a second. I got to tell you, it's not much help to point out that you're not a felon, that you're just a repeat misdemeanant. That's not really giving the court a lot of comfort. Here is what I am going to do. I am going to assert jurisdiction over the 30-day suspended sentence on the simple battery offense. I am going to revoke your suspended sentence in that matter, and you are going to serve 30 days on the simple battery. That is going to be the outcome of that case. On the new charge, I'm going to sentence you as follows. I'm going to sentence you to 60 days in custody. I'm going to suspend half of that for a period of 1 year. So you're going to serve 30 days on the new charge. You're going to serve 30 days on the suspended sentence because the prior judge imposed a consecutive, not concurrent condition on that suspended sentence. They're going to be run consecutive with each other. When you are finished with your period of incarceration, there will be a 1 year period where there will still be 30 additional days hanging over your head. The time has come to protect the community. That is my sense of things. So that is going to be court's order. When the 30 days up front is complete, you will be released on a suspended sentence with a remaining time of 30 days on the following conditions. First, you will report upon release from medium level supervision. Secondly, you will obey all laws. If you are found to commit any further offenses, it would be my indication to then revoke the additional 30 days and have that served consecutively with whatever period of incarceration is warranted for any future offense.
So
That's
basically,
going to be court's order.
they'll give me consecutive 30 days, right? So I'm
Yes.
gonna do like 40 something days, 45 days.
On paper, it's 60 days, and whatever you can manage to string together with good behavior within the jail, that's between you and the jail. That doesn't.
All right, that's
The
cool.
pragmatics of it are a little bit different than the court
That's cool.
side.
Judge,
cool.
how long did you want him
I'm
on?
gonna just do some voodoo on y'all. Please, real good.
Judge, how long do you want him on medium supervision?
1 year.
And
If
Is that testing?
yes, because I want him sober. So obey all laws, no drugs, no alcohol. I don't know if that's what's underpinning it, but we've got repeat antisocial behavior, including crimes of violence. The time has come to protect the community.
The hammer falls, 30 days for battery, 30 days for theft, and another 30 hanging overhead. The judge makes it clear this isn't leniency, it's protection for the community. What's your take on this tough ruling? Like, comment, and subscribe for more explosive courtroom stories every week.